Good evening, everyone, and welcome to tonight's Good Trouble Tuesday conversation, the fight for the ballot box, voting rights in the Deep South. I'm Nicola Hines, proudly serving as the president of the League of Women Voters of Georgia. It is an honor to join our sisters in the League of Women Voters of Alabama for this timely and urgent discussion. As many of you know, Georgia has long been a flashpoint in the struggle for voting rights. From the groundbreaking organizing of the civil rights movement to the modern day defense of our democracy. Our state has carried both the weight of voter suppression and the hope of historic turnout. We are proud that Georgia was among the states that inspired the passage of the original Voting Rights Act. But we are sobered by the reality that very protections once secured by law have been eroded, and in some cases outright dismantled. What we're seeing in Georgia today, from aggressive voter purges, burdensome ideas, laws, to polling places closure and shameful investigation, is nothing short of a coordinated effort to silence and shrink the electorate. But we refuse to shrink in the Deep South. We know that when Georgia and Alabama speak up, organize, and take action, the rest of the country pays attention. That's why tonight's conversation is so important, not just for our states, but the soul of this very nation. We're seeing attacks on democracy from multiple angles. Attempts to criminalize voter assistance, rollbacks to on-ballot access, and efforts to undermine local election boards. We're also seeing incredible pushback from our community leaders, everyday voters, and grassroots coalitions fighting back with power, persistence, and purpose. Today, we engage in this dialogue. Let us remember that the ballot box is not just a symbol of democracy. It is the very heartbeat, and it's up to all of us to protect it. Thank you for being here. Thank you to our partners in Alabama for walking this path with us. And thank you to every single person who continues to make good trouble in the name of justice and freedom. And with that said, I would like to hand it over to Kim Bailey, League of Women Voters of Alabama.
Welcome, everyone. So I am Kim Bailey, the president of the League of Women Voters of Alabama. Thank you so much for coming this evening to join us in this conversation. I'm sure you've all heard, as the South goes, so goes the nation. Nowhere is that more evident than in the ongoing struggle for voting rights in Alabama and Georgia. These two states sit at the heart of both the history and the future of American democracy. From the courage of the foot soldiers in Selma to the hard-won victories of the civil rights movement, Alabama and Georgia helped shape the Voting Rights Act and transformed the nation. Yet today, they remain central battlegrounds in the effort to protect and expand access to the ballot. Across these states, voters still face shifting rules, aggressive redistricting battles, limited polling locations, and new administrative barriers that disproportionately impact rural communities, voters of color, and low-income families. Alabama and Georgia continue to be at the center of landmark court cases and national debates, clear proof that the struggle for equitable voting rights is far from over. So thank you for joining us for this critical conversation. The path forward for voting rights in the Deep South, and indeed for the nation, depends on engaged communities, informed advocacy, and a shared commitment to protecting every voice at the ballot box. So now I'd like to turn it over to our moderator, Stephanie Butler.
Good evening, everyone, and welcome to tonight's panel hosted by the League of Women Voters of Alabama and of Georgia. My name is Stephanie Butler, and I will be moderating tonight's discussion on the history and, more importantly, the current state of voting rights in the Deep South. Our focus will be on understanding where we are right now, the barriers voters face, the legal and political forces shaping access to the ballot, and the strategies communities are using to protect and expand the right to vote. We're very fortunate to be joined by 4 experts whose work spans litigation, policy, organizing, and on-the-ground advocacy across Alabama, Georgia, and the broader region. We will spend the next hour in a structured Q&A format, and we hope to have time for Q&A at the end. So please add your questions to the chat, and the LWV team will be monitoring and collecting your questions. Let's start tonight by meeting our panelists. Thank you all so much for being here. And I'm going to ask you all to take a minute or two to introduce yourselves and your organization. And we'll start with you, Jatan.
Well, good evening, everyone. Can folks hear me?
Yes.
Wonderful. Good evening, all. It is an honor to be in community with the League of Women Voters, who are a close partner to the ACLU of Alabama, which I serve as executive director. The ACLU of Alabama has a long history of civil rights and civil liberties work. We are celebrating our 60th year. I've been with the organization for a decade. Our focus within the ACLU of Alabama is a statewide entity. We do our work in 3 ways. We do it in the courthouse, which you all are very, very familiar with. We do it in the state house through legislative advocacy efforts, and we do it in community as far as our public education and organizing efforts. And that is a critical aspect of our work. We also focus on 3 core issue areas: voting rights, criminal legal reform, and gender justice. And all of this work we define as intersectional. We use an integrated advocacy model, understanding that organizers and litigators and policy strategists all play a key role in how we elevate the work of civil rights and civil liberties and ensure that it is people and centered around community. And so that is a bit of the scope of the work that we've done, but glad to be in partnership with so many individuals, not just on this call, but so many of you are in community with. So thank you so much for having me.
Thank you. And Imani, a few words about yourself, please.
Good evening. My name is Imani Brooks. I am a policy fellow at the NAACP Legal Defense Fund, the nation's premier legal organization fighting for racial justice. Through litigation, advocacy, and public education, LDF seeks structural changes to expand democracy, eliminate disparities, and achieve racial justice in a society that fulfills the promise of equality for all Americans. Founded in 1940 under the leadership of Thurgood Marshall, LDF was launched at a time when the nation's aspirations for equality and due process of law were stifled by widespread state-sponsored racial inequality. And 80 years later, LDF has prioritized its work protecting the right of Black citizens to vote, representing Dr. Martin Luther King Jr. and the marchers in Selma, Alabama in 1965, advancing the passage of the Voting Rights Act, and litigating seminal cases interpreting its scope, and working in communities across the South to strengthen and protect the Black political power. So I'm delighted to be here today to bring the history and work of LDF with me to this distinguished panel and discuss the state of voting rights across the Deep South. Thank you for including LDF.
Thank you. Ajay, would you like to introduce yourself, please?
Sure. Good evening, all, and thanks to the League of Women Voters for organizing this panel. My name is Ajay Singh. I am a senior staff attorney in the Democracy and Voting Rights litigation team at the Southern Poverty Law Center. Southern Poverty Law Center is an organization that's been around since 1971, fights for racial justice in the Deep South. Our core states are Louisiana, Alabama, Mississippi, Georgia, and Florida. We work very closely with communities on the ground to work to dismantle white supremacy, strengthen intersectional movements, and advance human rights for all people. We have litigation arms, which I work in one of them. We also have projects that focus on education rights, hate speech and hate groups, criminal justice reform, as well as economic justice. I'm sure I'm missing some others there. And then we also have some very robust policy folks who work on our team to help push change across state houses all across the South, as well as in the nation's capital. So we are working very hard these days on a number of different issues, including democracy and voting rights, which is where I focus and which I'm excited to talk to you all about this evening.
Thank you. And Danielle.
Good evening, and thank you to the League for hosting this important event and for inviting me to be here. My name is Danielle Lang. I'm the Senior Director of the Voting Rights Program at Campaign Legal Center. Campaign Legal Center is a national nonprofit that is focused on advancing democracy through law. So we focus on all areas of election law to try to create a democracy that works better for all Americans, especially historically disenfranchised communities. So we work very similar to other groups that have introduced themselves. We try to use all the tools in our toolbox. We are litigators, but we're also policy makers. We use administrative advocacy. We use every tool in our tool belt to get access to the ballot and to create a better American democracy. I oversee our voting rights program. We work in 4 basic areas of voting rights, redistricting, ethics, and campaign finance. And I oversee all of our voting rights work. And I've had the great opportunity to work with ACLU of Alabama, LDF, and SVLC on good trouble fights for voting rights in the South. Unsurprisingly, a lot of our work, although we're national in scope, is in places like Alabama and Georgia and other places in the South. And so I'm really excited to talk about our work and kind of have this discussion about where we are today in this long-standing struggle.
Thank you. We're really fortunate to have all of you here today. Thank you so much. I want to jump right in because we don't have a lot of time. Jitana, I'm going to start with you. Don't want to spend a lot of time here, but it is so important to connect our history to where we are today. So can you talk a little bit about the legacy of Jim Crow and the victories of the civil rights movement? How are those things shaping today's voting rights battles in places like Georgia and Alabama?
Thanks so much for that question. I think it's important for us to go back a little ways, and I promise I will not be very long-winded in this, but to get to Jim Crow, we have to talk about the history of Reconstruction. And that history in a short time really allowed us to come up with what we call the Reconstruction Amendments. And those are really a cornerstone when we talk about the Constitution. So the 13th Amendment that abolished slavery, the 14th Amendment that ensured citizenship and naturalized citizenship for those who were enslaved and the children of those enslaved, and the 15th Amendment, which provided the opportunity or created a law for Black men to be able to vote. And they were respectively passed between 1865 and 1870. And then we get to 1877 when Jim Crow laws are essentially enacted, post the Black Codes, as there was a pulling out of the Union troops from the Deep South. And that's when we get into a real history of what it means to historically disenfranchise a people. And from that time, I say 1877 on, there has always been a fight and a struggle for access to the ballot and full reenfranchisement for Black people in this country and historically marginalized communities. And so what we learn from this history of Reconstruction, which is really the vision and the dream to the nadir of Jim Crow, in which we are now in another nadir in this time, is the ability for us to see progress through the courts. And now we are seeing it through the people, right? And still the Supreme Court is pivotal in that. And so when we see the passage of the Civil Rights Act, but really also the Voting Rights Act, that allowed us a real win for civil rights. We will talk about the Shelby decision, but that provided us an avenue in which people had access to the ballot. And there were specific states that were acknowledged. Alabama, Georgia, Mississippi, and several others were a part of this Section 4 that helped define what Section 5 is. It gave us the ability to vote and to have access to the ballot. That was a huge win for folks. And now we are seeing the rolling back of what that means. So when we see the arc of civil rights and within our communities, we have to look at what the Supreme Court was able to help define. And now, as we are in this particular century, and we are seeing the Shelby decision and the Milligan decision, and now Calais, it really gives a scope of what the Voting Rights Act did and what the effort now is to roll back the ability to enfranchise a people. And now we are looking at disenfranchisement across the board, not just for the Black community, but across historically marginalized and historically silenced folks. So that is really the arc. We can talk about the wins, but we have to talk about what those wins and that level of visibility does when folks are really steeped in this foundation of understanding that white supremacy and this effort is about power. And when we shift the power of the people, it also shifts how we look at and how we approach power now at this particular time.
Thank you. And Imani, I'm going to turn to you. We have a lot of issues that we will discuss in detail tonight, but can you give us a broad picture? What is the general landscape that we're looking at for voting rights in the Deep South today? Are we in a good place? Are we in a bad place? Do you feel hopeful?
Yeah, I will say I feel hopeful, but I will be bearing some bad news first, before I get to the hope. So I think, LDF's President Director Counsel said it best when she testified in front of the Senate Committee on Rules and Administration last year. The state of voting rights for Black Americans is tenuous. There's longstanding protections that have been weakened and under further threat. And there's just alarming backsliding on our most fundamental right, the right to vote. And I would be remiss if I don't mention Calais is one of those examples. About a month ago now, our director and president counsel did argue before the Supreme Court in Louisiana versus Calais, and I'm sure we're all waiting with bated breath for that decision. But it was a case about equal representation for Black voters in Louisiana and the role of race in redistricting. And this is the latest attempt to erode the protections of the Voting Rights Act, and by aiming to limit Section 2's application in the redistricting process. But there should be no question that the facts and the law are calling for fair maps. And this is not just about Louisiana's specific map. It's about whether communities of color across the country can have meaningful representation. And I think that's really at the heart of what we're trying to do at LDF and with our peers here is ensure meaningful representation across the South. So we have been looking at LDF outside of litigation, also on the ground, through monitoring programs and advocacy to really get an idea of what it means to be a Black voter in the South. And there's a few, 4 or 5 main areas that we see are kind of defining the experience for Black voters. Criminalization of voting and voting assistance, intimidation of voters and election workers, disinformation targeting Black voters, limited access to the ballot due to inefficient and ineffective election administration. And there are some, ongoing cases around these things, but it's important to kind of think about what can advocacy do to make sure that these issues are addressed, so there's high turnout, and so that people can elect candidates of choice. And so that's a little bit of a combination of our litigation perspective and our on-the-ground perspective to give you a picture of the current landscape of voting rights from our work.
Thank you. And I'm going to come back to you, Jatan, because you brought it up, and it's really important and so central to this conversation that the thing that shifted all of this was the Shelby County versus Holder decision not so long ago. I hope that most people on this call do have some concept of it. But can you just give us a broad overview? What was that decision and what has it taken away?
So sorry about that. Ultimately, the Shelby decision in the broad context took away Section 5 of the Voting Rights Act. And I remember as I was getting read in on this over the years, what is Section 5? Essentially, when the Voting Rights Act was enacted, there were various sections, and this particular section was actually defined essentially by Section 4, which stated at the time there were a certain number of states in which less than 50% of the voting right age, and of course, I can be corrected on this by Danielle and Ajay, who are attorneys and can really give us guidance on this. But essentially, that provided a test or a reasoning as to why we needed Section 5. So in broad terms, Section 4 said, hey, there are very particular states who have historically limited access to the ballot. And these are the particular communities in which they have done it in. So we need to have a mechanism by which we are monitoring these states. And that is what Section 5 does. It is what they called a pre-clearance. So before you could make any changes, whether you're changing a polling place or shifting something, you had to get a pre-clearance by the federal government. And historically, that's important to know because they say what is it? Is it Missouri is the show me state, Alabama is the make me state. So anything that Alabama has done historically has been by way of a federal provision or intervention. And that is what pre-clearance did. Pre-clearance required the federal government to ensure that Alabama was providing access to its communities as it related to access to the ballot, polling places, ensuring that we had a election, essentially election protection mechanisms in place that were not the state, because the state were not standard bearers of accessible elections. And ultimately, what Section 5 did at that time in Shelby County, they said, we no longer need this. This was in 2013. They said, we no longer need this particular provision. We are in, and what the court named a post-racial society. And after that, what we saw is an onslaught of voter suppression tactics, whether that was voter ID laws, the closing of particular polling places, voter purging. We can get into those details. But what Section 5 did was strip that ability, that protection for community, because it said we were at a place that we were not. And now we are still scraping by to maintain the current sections that are still in the Voting Rights Act. And now the one that is at play and is at risk is Section 2. So Section 5 really limited our ability to have the protections needed so folks were able to get access and able to vote. And I think I can get into the closures and many of those other things that so many of us are familiar with later, but that's ultimately what Section 5 did. And the irony or the duality of Alabama is the history of progress, but the history of regression. We are the state that was truly the catalyst of the Voting Rights Act. We are also the state that has been so regressive in essentially ensuring that access to the ballot has been secured. And so that is a little bit about Shelby and its impact currently as we are looking now approximately 15 years later.
I think it was Justice Ginsburg who said something like getting rid of the section was like standing out in the rain with an umbrella and then getting rid of the umbrella because you're not getting wet. I mean, the logic was so foolish. And Ajay, will come to you because when our state election boards saw this opportunity, they made some changes. What does the election board do? What kind of changes have they been able to make? And this is not even getting into legislation yet. What kind of changes have just the boards made?
Sure. So I think you're referring specifically to the Georgia State Election Board.
Yes, thank you.
So in Georgia, there's a Secretary of State. I think we're made quite a bit of headlines in 2020. Brad Raffensperger, and who's the chief election officer of the state of Georgia. They also have a state election board, which is charged ultimately with developing rules and standards for implementing the state election code. They're charged for investigating irregularities in elections, and they're charged for making recommendations on the conduct of elections. I bring up the Secretary of State because in prior years, it was the Secretary of State who chaired the state election board. But recently, after the 2020 election, the state legislature removed the Secretary of State from the state election board, or not removed, but changed the structure so that the structure is a little bit more partisan than it was before. And now you're starting to see the state election board in Georgia basically engaged in openly attempting to restrict ballot access and manipulating counting. So specifically in 2024, there were a number of rules that the state election board attempted to pass, or did pass actually, one of which required hand counting by all election officials of ballots in Georgia. Really tedious process. They also tried to expand the ability of county officials to engage in kind of inquiries about suspicions about vote counts before certification. The underlying ideas here was that, through these types of measures, you would delay the counting process, sort of stretch it out, and potentially give opportunities for either, an election official in some county or some, individual private actors to challenge and overturn kind of finished elections. These issues were ultimately litigated. The Supreme Court of Georgia stepped in and said that the state election board had actually overstepped its authority, was acting in excess of what the state legislature has sort of set out in the election code, and couldn't actually provide these kinds of regulations in these ways. So for the time being, we have a state election board who has been kind of reined in by the Supreme Court in Georgia. It's having said that, that doesn't necessarily mean that they are just going quiet. We're entering into another major election cycle in Georgia in 2026. We're already seeing the board try to use its investigative powers in ways to impact the way that county election officials are operating their investigations, being opened and reopened into Fulton County, really targeting areas with that, some of the most diverse areas in the state of Georgia. We're starting to see them, already make recommendations to the legislature about changes to mail voting and other other ballot access issues, asking the legislature to step in and try to restrict those changes. So we're starting to see a more sort of active state election board trying to reassert its power, I think, and the next few months we'll see how effective they are.
We have these appointed boards that feel like they're working hand in glove with the legislature. Like they want to do something and they can't quite do it. They make a recommendation to the legislature. Hey, we'd like you guys to, give us the power to do this or change the rules so that we can do this. And the wild part about it is they're doing it in the name of election integrity. Jatan, based on what we know, does the data show that what is it showing between voter fraud compared to the number of eligible voters who are actually disenfranchised by the rules? I mean, where's the balance here?
To be clear, there is no balance. And let me just be clear about that. And the reason there is no balance is because this idea of election integrity or voter fraud is essentially non-existent. And the ACLU of Alabama was very fortunate to be able to sit on what they called a study in which the Secretary of State conducted what voter fraud looked like in the state of Alabama, an election integrity study group. And essentially what they found that it was not an issue. Now, because we sat on that committee and it was dictated by the Secretary of State at the time, John Merrill, there was not a counter to that. So they did not talk about issues around voter suppression or issues around broadly election subversion. And when we talk about election subversion, in this time, it is a particular entity, elected official, someone with power saying, I don't believe the results of this election. And we are seeing that now more so than we have previously. Essentially, what we understand is that voter suppression is overwhelmingly the core of what we talk about when there are any issues regarding elections. Again, I don't like to use and the certain phrases for certain narratives, because that diminishes what we need to focus on. The focus has to be on ensuring people have access to the ballot. The focus has to be on a state voting rights act. The focus has to be on the fact that Alabama is one of only a handful of states that does not have early voting access. We do not have, we are limited in mailing and voter mailing access. We are still having conversations about what access looks like in this state each and every legislative session. And so that's what really needs to be the focus when we talk about voter access writ large. Voter fraud is a red herring. It is a narrative for something that does not exist. And quite honestly, if you follow the Alabama legislature, or oftentimes any legislature in the Deep South, what you're going to see is they make solutions for problems that do not exist. And that is what is at the core of that particular narrative.
Let's walk through some of these specific measures that state authorities have implemented to set up these barriers to voting. I want to start at the very beginning of the voting process, which is voter registration. Ajay, this is for you, and Danielle, we're going to add your voice to this conversation. Ajay, you've worked extensively on issues related to the National Voter Registration Act rules regarding voter list maintenance. And Danielle, you've litigated voter roll maintenance cases. Could each of you briefly break down how so-called purges happen and what safeguards are supposed to prevent abuse of the voter roll maintenance process? Danielle, can we start with you?
Sure, I'm happy to do that. So to kind of like break down a few concepts here, we have a system of voter registration in every state in the country except for North Dakota. And that system, we're all familiar with it. You get registered to vote, and that way you can, know what polling place to go to, and you present your name and whatnot. And of course, we need a way to keep that list up to date. People move, people pass away, people, have lots of reasons why, somebody might become ineligible to vote. There are a number of reasons why we have to keep it up to date, mostly moving and passing away. And that's, millions of Americans every year. And there are good systems in place to keep track of folks as they're moving or passing away and cleaning our rolls. But that process of removing people from the rolls on a regular basis obviously creates opportunities for abuse. If you are removing people in very large volumes on flimsy evidence that they have actually moved or that they are ineligible, what you will end up with is many voters showing up at the polls and finding themselves no longer on the rolls. And so there is a necessary process of list maintenance that has to happen, but it also creates huge opportunities for abuse. And we've seen that play out over and over again. Here are some ways that states use as a reason for list maintenance that really don't make any good sense at all. One is failure to vote. So if you just don't vote for a while, states will say, oh, that's evidence that you've moved. We think you've moved because you haven't voted here for a while. Of course, there are just many times where voters sit out a few elections, and then when they show up and want to participate again, they find themselves off of the rolls. They might use kind of like systems that try to kind of match various records to find people who've moved, but they use unreliable records. You use commercial data or something along those lines, or you have really bad matching systems so that you're finding the wrong Kathy Jones or whatnot, and matching them incorrectly, and you can end up with incredibly high volumes of removals, and voter registration issues are the number one phone call issue that we get at election protection every single election. That is the biggest barrier to voting for Americans. And I think that, these big major purges are a huge part of that. Unfortunately, the Supreme Court has kind of cleared the way for some of that because the NVRA has some protections in place for list maintenance. I'm going to talk about the ones that still exist. But for example, one of them was to say failure to vote should not be a reason why you get kicked off the rolls. And yet the court has said that as long as they also send you a notice, they can use that as a reason to kickstart pushing somebody off of the rolls. And one last example I'll use from 2024. I litigated a number of cases that were about a list maintenance practice that actually pretty surgically targeted new Americans, which is trying to find, alleged non-citizens on the rolls. What Alabama, for example, I'll use as an example, Alabama did is it kind of took data it had about non-citizens and tried to match it against their voter roll. But in doing that, they used DMV data or, their data from their driver's license agency, ALEA, and what that found was not non-citizens on the rolls. What it found was people who were not citizens when they got their driver's license, became citizens, registered to vote, and we're getting targeted by this stale data. That's an issue that has replayed itself in numerous states. I've litigated the issue in Virginia, in Georgia, in Arizona, and it kind of replays itself over and over again. This use of stale citizenship data that really surgically goes after these new citizens that, are kind of just trying to join into our democracy, and states are throwing up roadblocks. We do have a number of NVRA protections left, though, and maybe I'll let my colleague kind of talk about some of those.
Ajay, I think she's throwing it to you.
Sure. So, I think that, the protections that I've used in the NVRA context, one is sort of just the kind of notice and wait period, right? So, when a state has identified a particular voter, or a county election official has identified a particular voter as having potentially moved, there are requirements under the NVRA that include, providing individualized notice to the voter through, the voter's contact on file, usually through a mailer, and then a period of inactivity following the mailing of that vote of that mailer. Usually it's two federal election cycles. So what that means effectively is that, once you go and look at the National Change of Address database and identify a voter as potentially having, and effectively match that voter, with what record is in that database, you have that, notice and wait period to see if they, subsequently cast a ballot or subsequently get in contact with their election officials, at which point they have to be made active once again. So there's this, that particular safeguard is built in there. The other big safeguard that is in the NVRA is the 90-day quiet period, which prevents election officials from engaging in, what we call systemic list maintenance activities within 90 days of an election period, of an election day. So, that basically means, can't be going through and doing mass cancellations 20 days before an election. In fact, if you're going to do this type of list maintenance, it typically occurs in off-year elections. So, for instance, in Georgia, you will see, as just recently occurred, a lot of headlines about large numbers of voters being put through this list maintenance process and being purged. That typically occurs in off years, in an effort to avoid getting close to that 90-day quiet period. The other protection under the NVRA is that any of this list maintenance activity has to be uniform and non-discriminatory. And there, it's really a question about, are you targeting, are these efforts being used to target particular communities, particular geographies? So those are, some of the explicit protections that are in the NVRA itself, that, help to ensure that at least states are abiding by some standards here.
And I want to follow up with you and get into something that is pretty wonky, but I'm seeing who are participating in this call tonight, and I think they'll appreciate it. Alabama abandoned ERIC. It was an organization that is intended to help states improve the accuracy of their voting rolls, this list matching that you and Danielle both mentioned. And in its place, the Secretary of State created something called AVID, or the Alabama Voter Integrity Database. Can you speak a little bit to what we know, or maybe even more importantly, what we don't know about how AVID works and how it differs from ERIC? And what does this shift mean for voters and for list maintenance?
Sure. So I can talk about it at kind of a general level, and I'll sort of, I encourage any of my colleagues to jump on and fill in some of the details here. But, as I know it, ERIC is the kind of the best sort of system out there for conducting this type of list maintenance. It is a it's a compact between multiple states. It's a nonprofit that compiles information from multiple different states and shares it across state lines, allows, for sophisticated matching, has voter records, uses, has pretty high standards, incorporates transparency and audits to ensure that there's, some level of accuracy in what they are doing on a day-to-day basis. My understanding with AVID is that none of those things really apply there. It's run by a single state, the state of Alabama. It involves agreements with 10 other states to share information between Alabama and those 10 other states. So it's a very centralized system, all of which is run through Alabama. It is, doesn't have the same kinds of safeguards, doesn't have the same kind of auditing and third-party oversight, transparency involved. So it's really hard to get a sense of, what it is doing and whether it's resulting in, false positives, false negatives. It's really hard to even really say. And, from what I understand, the AVID system also doesn't even incorporate all of the relevant information that would be necessary to run a robust voter list maintenance check. So for instance, I've seen suggestions that they don't actually incorporate information about social security numbers and driver's license information, which makes matching incredibly difficult to do if you don't have that information. So it is a far less reliable system for doing voter list maintenance. And I understand the state of Georgia is considering leaving ERIC and potentially, either going to AVID or another system that is, troubling, and suggests, a lot of this is informed ultimately by, frankly, I think conspiracy theories about what ERIC is and how it operates, that really are not based in fact about, its actual operation on a day-to-day basis.
Thank you. And Danielle, I saw you nodding. Do you want to add to the conversation?
Yeah, I'll just say, the idea that Georgia is now thinking about leaving ERIC and joining AVID is so frustrating because, Secretary Raffensperger has said in the past that that's like kind of shooting yourself in the foot, that ERIC is by far the most accurate way to actually effectively remove large numbers of voters who've moved, which everybody agrees should be a goal, like to keep our rolls up to date where you can, as long as it's accurate and it's not endangering voters. So it's so frustrating. The other thing I'll say is, I do not have a lot of visibility into the current AVID system because nobody does, so far as I can tell. But in litigating last year, the system that was kind of ad hoc put up for list maintenance during the 90-day period, which we sued over about, trying to find alleged non-citizens. I had some insight into how they were doing that matching, and it was our expert was, kind of shocked at the lack of kind of clarity, detail, care being put into a matching system. It wasn't really being done by experts. It didn't have any of those safeguards in place. And so I'd be really concerned. I am really concerned about kind of just the technicalities here, right? Even if everybody was well-meaning, this is a hard thing to do well. And Eric, spent years and years crafting the kind of technology and expertise to do it well, and no real reason to believe that's what's happening now through the Avid system.
Thank you. And we're going to stick with you, Danielle, because another component of voter registration is voter documentation. And it has really become a significant barrier with the new rules that are being implemented. Can you explain some of the changes that have been made to voter documentation requirements, and why is asking voters to verify their identity so problematic?
Yeah, it's a great question. There's nothing wrong with asking voters to verify their identity, and we always have, and I think we always will do that. And we have a lot of tools to do that. We, do signature matching a lot of times. We'll do kind of like you send notices to the address that you list. We kind of verify your information against, the Social Security database or the driver's license database to make sure there's an identity match. And if there's not an identity match through one of those systems, then you can provide a utility bill or whatnot. And so there are these baseline systems for providing identification of voters. What becomes a problem is when you try to layer on more and more documentation requirements that just make voting into a bureaucratic nightmare, especially for some of our least for those who are kind of most marginalized, those that have the fewest resources, it can become a really bureaucratic nightmare. So, the earlier wave of documentation was all about voter ID, which of course disproportionately hurt people who don't drive, people who are students, et cetera. But the new wave that we're seeing now goes a step further, and is now just not only do you have to show me your ID, but you have to show me an ID that proves that you are a U.S. citizen. And there are at least two layers of extreme kind of hardship that this can put on voters. One is that a lot of voters just don't have this type of documentation. A Brennan Center report put out about 9% of Americans are unlikely to have easily accessible to them the type of evidence that these laws are often demanding. If you don't have, a lot of Americans obviously do not have a US passport. And so then the most common other piece of evidence you're going to have is either a birth certificate if you're a natural born citizen, or, naturalization papers if you are a naturalized citizen. But of course, lots of folks, don't have their birth certificate. Students don't have it on them. People lose that documentation. They have it elsewhere. It can cost money to replace it. It can take time to replace it. And if you are married, and you've changed your name, your birth certificate is not going to match your voter registration name. And so you're going to need to have another document to make that link. So there's that burden of just having the documents, but there's a second burden that's at least as problematic, which is that it just makes voter registration a lot harder if you have to prove your citizenship at the time of registration, right? Because a lot of Americans register to vote, when they are at the post office or at the supermarket, when a lovely person from the League of Women Voters offers them a voter registration form. But you're not going to have, even if you have a birth certificate in your attic somewhere or whatnot, you do not have it with you at the supermarket. And so all those opportunities to bring new Americans into, bring Americans and more Americans into the democratic process are kind of cut off at the knees. And in the states that have implemented this, like Arizona and Kansas have had some opportunities to implement this for at least some period of time. We've seen huge numbers of, people, tens of thousands in Kansas, for example, who were unable to get registered, even in a short period of time that law was in place. In Arizona, there's, I think, I can't remember, but I think it's, upwards of tens of thousands of Arizonans that are on what they call a federal only list, because Arizona is not allowed to implement that requirement for federal laws. Alabama and Georgia both actually have documentary proof of citizenship laws on the books, but they have not enforced them because of a Supreme Court ruling about the Arizona law that would require them to have a dual system where you could only have that requirement for state and local elections and not for federal elections. But this is the fight that President Trump is trying to pick. That he tried to address the documentary proof of citizenship issue in an executive order, which Campaign Legal Center sued over, and we have obtained a permanent injunction against that part of the executive order. Now, the case isn't over until it goes all the way through its appeals. But that's the kind of the fight, I would say, that we're having on kind of voter access today.
So we've talked a lot about barriers to actually even getting access to the franchise. Let's talk a little bit about the barriers in casting your vote. And Imani, I'm going to come to you to talk a little bit about absentee voting. It's being restricted in a lot of states, especially across the Deep South. Mail-in early voting. Can you talk about why these options are important for ballot access and what are the arguments being used to restrict them?
Sure. Absentee and early voting are really important for several reasons. They reduce the time, cost, and any risk associated with voting. They provide safe and secure ways for voters with disabilities and health concerns to cast their ballots. We saw that, in COVID. And then it increases voter turnout, which is crucial for fair representation. And these methods are increasingly used for rural voters, students on college campuses, and voters who rely on public transportation. So these methods really bring in a lot of people into the voting process. Still, there is fierce debate over these methods, simply because they are accessible and common sense voting methods, and they are frequently used by Black voters. There's typically intense backlash when Black voters use these methods, and we saw this in 2020 when there's election of the first vice president of African and Asian descent, and in Georgia specifically, the first Black and first Jewish U.S. senators. And after that election, there was more than 400 bills introduced across the country, in nearly every state, aiming to restrict the franchise because of that intense turnout. So some examples in the South of what that looks like: in Florida, Black voters increased their usage of absentee ballots as a result of the pandemic, as seen in a lot of places. And we saw SB 90 severely curtail the use of unstaffed ballot return drop boxes and effectively eliminating community ballot collection. And then in Georgia and Texas, after strong early in-person turnout among Black voters, lawmakers tried to outlaw or limit Sunday voting in a direct attack to the Souls to the Polls turnout efforts by Black churches. And while LDF and other organizations intervened in these places to remove those laws from the books, in Georgia and Texas in particular, the final forms of the enacted bills remain extremely harmful to voters of color, contributing to this wide racial turnout disparity. And so there's a lot of different arguments around why on the other side against these methods, but a driving argument is that vote by mail is not trustworthy. And so we did some litigation in Mississippi, Illinois, North Dakota, and this kind of shows that, in the Deep South, this is an issue, but it's also a tactic across the country to come after accessible ways to vote. And in those states in that litigation, there's a fringe theory that was used, and it essentially said that setting the date of because federal law sets the date of federal elections, that prohibits states from counting timely cast mail-in ballots received after Election Day. And then we also saw public officials pushing this narrative that vote by mail and other early voting methods are not trustworthy. Mississippi's Secretary of State publicly discouraged voters from voting by mail because of purported USPS mail delays, despite the fact that USPS delivered nearly 99% of trackable ballots from voters to election officials within 3 days of the 2022 midterm elections. And I think someone put in the chat, that USPS is being dismantled by this current administration to try to retroactively show that, voting by mail is not trustworthy because there's no USPS anymore. But all of the things I've said, it's important to realize that it's targeted measures because people of color are turning out or using these methods. First-time voters are using this method, and it's hurting this other side. But that's a little bit about just kind of why it's important, and then the arguments against these important accessible options.
So there's all kind of reasons why people argue against the early voting options. So surely they would make in-person voting on election day easy, right, Chatan? I want to ask you about polling place closures and consolidations. These have been happening across the South, especially in rural and minority communities. Talk about the practical effects for voters with limited transportation, technology access, disabilities. What's going on with this?
Thank you for this question. And the reason why it's important to me is because not long after the Shelby decision, I was recruited and started my job at the ACLU of Alabama. And the reason why this conversation is so poignant is because a little bit about my history. My grandparents migrated to Chicago in 1959. And the reason that history is important is because one of the reasons my grandfather always says that he migrated were a few things. One was access to the ballot, two was for better health care, and three was for job opportunity. Just very core things. And so when we talk about the second iteration of the Great Migration, where 6 million Black folks migrated to the north in areas like Detroit and Cleveland and Chicago, there is a history of why this is important. So I returned to Alabama in 2015. And during that time, in the fall of 2015, what we saw was an onslaught of closures in rural Alabama. And the irony is that one of those closures, at least several of those closures, were happening in the Black Belt, where my grandparents were from, and specifically in Sumter County, Alabama. And so when we talk about access to polling places and the consolidation of polling places, what we're really looking at are access to Black and rural-based Alabamians. That is what is important. We do not, in the state of Alabama, have a mass public transit system. We especially don't have those in rural communities. And so when we are looking at these poll closures, we are looking at folks who may not have the ability to get to a polling place. We are looking at folks who also may not have access to some of the things that are needed. So when we talk about technology and broadband and things in which you may get notified that your polling place is closed, that causes an issue. This last midterm election in 2024, we received over 300 calls, not just in rural communities, but in places like Birmingham, Alabama, right outside of Shelby County, in which we saw several polling closures, or the fact that people were not at the polling place that they originally were. When you have a state in which you do not have off years of election, you have some type of state or municipal or local election or special election in some capacity, you don't have the same polling places. Where I vote for the general election is not where I vote for a municipal election, and that causes issues. And the reason poll consolidation and poll closures are tied, and it's tethered, is because that constantly causes issues. When you also do not have standards amongst folks like court clerks and the folks who are supposed to dictate or provide essentially a streamlined process for people to be able to vote, and that is not standard across the state. So overall, or overwhelmingly, we are seeing poll closures, but we also see that there is, to use the term, a reverberating effect of what that does when people try to show up to the polls. They are either unable to do so, they are not provided the information, right? That goes back to Section 5. Or essentially, to Amani's point, they may step back from an election. They may not vote in a certain election, and now all of a sudden they're not on the roll. And I want to make sure that I named the right person who said that. That might have been Danielle. But essentially, what we are seeing is a major issue. Poll closures are an impetus for so much more. It is a spoke in a larger wheel of ensuring that we are limiting access, and it is a practice of not just racial disenfranchisement, but a racist practice that we have known all too well historically. And to see it happening now really is just a way to shift how we talk about it. So we always have to be mindful of how we are utilizing these narratives and ensuring we are utilizing narratives that are focused on understanding that this is about disenfranchisement of people, and these policies are steeped in racist policies that are very foundational to the history of this nation and very specific to the Deep South.
On that topic, let's talk about some of the another highly racist policy regarding voting, and that's felony disenfranchisement. The Sentencing Project showed that 8.6% of all Alabamians eligible to vote have lost their voting rights through felony disenfranchisement. But that number is 15% for Black Alabamians. And Return My Vote has shown that Black Alabamians are 4 times more likely to lose their right to vote than white Alabamians. Danielle, let me come to you. Alabama's felony disenfranchisement law is one of the most restrictive in the nation. Can you explain how this system works, especially something called the moral turpitude clause?
Sure. I've spent a long time thinking about Alabama's felony disenfranchisement law. I've been working on it in some form or another since 2016. That was one of my first cases at CLC. So Alabama's Constitution has a law that says that you are disenfranchised, you lose your right to vote if you are convicted of a crime involving moral turpitude. What does that mean? I don't know. It is well established that when that law was put onto the books, which was in the 1901 Constitution, it was a Jim Crow Constitution. As we talked about at the top of this call, it was passed for racially discriminatory reasons. And in fact, there is a Supreme Court case that addressed that provision and its racially discriminatory background, but it was in a case that was only about kind of application of that law to misdemeanors. And so it kind of kept on the books the felony disenfranchisement component of it. And until, a few years ago, I guess quite a few years ago now, but until we filed our lawsuit in 2016, there was no definition of what was a felony involving moral turpitude. It was just kind of a guess. It was kind of up to registrars. As you can imagine, it meant that people just assumed that everything was a felony involving moral turpitude, that if you had a felony, you couldn't vote. And that was the assumption that most Alabamians with felonies assumed, because there was no guidance available for them to know if they were eligible to vote or not. After we filed a lawsuit about that issue, Alabama did finally pass a law that defined moral turpitude to a list of crimes. Here's the good news about that. it re-enfranchised about half of people with felony convictions as a result of that kind of like actually having a list for the first time of disenfranchising crimes. That meant that there were also felonies that were not disenfranchising. The bad news is two parts. One is most Alabamians still don't know that, right? That's like an incredibly complicated system, and Alabama has not done basically anything to try to make that information more transparent. And that's where we've actually done a lot of work directly with the league on trying to address that. So thank you to our league members for all that hard work. The second part of the bad news is that the list, while it's smaller, and so therefore lots of people got their right to vote back, the list is disproportionately geared at Black voters. Our expert did an analysis and showed, once again, even, obviously the population, because of our criminal justice system and its own racial disparities, the population of people with felony convictions in Alabama is disproportionately Black because of the criminal justice system. But even kind of taking that constant, even among that population, this particular list of crimes specifically and disproportionately affects Black voters. So we have a lot of work to do, both to make sure that voters who do have the right to vote or who can get their right do have the right to vote or can get their right to vote back are able to do so, and two, to kind of get rid of this scourge altogether in Alabama. I'll note on that kind of second point, there is a process in Alabama, at least, to get your voting rights back. That's the good news. Even if you lose your rights, you can get them back. There is a process. Bad news, it has a poll tax. And if you are unable to pay, say, your fines and fees related to your conviction, it's all but impossible to get your voting rights back.
Mm-hmm. And thank you for recognizing the league's efforts. And we are grateful for Campaign Legal Center's partnership in our voting rights restoration projects and for the wonderful partners we have here on the ground. Chetan, can you talk a little bit about the grassroots on the ground work to do voting rights restoration, whether it's policy reform or actually assisting people with restoring their own rights?
It's really twofold, and thanks for that question, Stephanie, and shout out, of course, to Campaign Legal Center, League of Women Voters. So many of us in coalition for several years now have consistently introduced the voter restoration bill, which essentially tries to automatically restore the voting rights for individuals who are not who do not have a crime of moral turpitude on their record. And so I think that that's a big aspect of this. Before we can get into the voter restoration piece, I, again, like to do a scaling of to see where we are. So Alabama's Black population is a little over 25%, approximately 27%. And our population of Black Alabamians who are in our prison system is over 50%. Nationally, the Black population is just at 13%, and the Black prison population is at 33%. So you see nationally and locally how that is double. And so we have to talk about this history and this understanding of incarceration as a core issue. And when we look at incarceration as a core issue, and particularly in Alabama, because it is a humanitarian crisis, also elevating the Alabama Solution documentary for those of you who have not seen it, which really provides you the scope of looking at our prison and our carceral system. It's important because this is an aspect of voter enfranchisement and voter restoration specifically. We cannot continue having a state of incarceration that also penalizes those who come out seeking the right to vote. And one of the core aspects of this that Danielle touched on is there is a process. So you can look at reports around fines and fees. Alabama Appleseed has an incredible report around that. But particularly, we have to also look at the Board of Pardons and Parole, which dictates that as well. And so when we look at how prohibitive fines and fees are, we also have to look at the parole board, in which it is required a full pardon depending on the conviction, that you have to have a full pardon to get your full restoration, your full fully enfranchised. One of the aspects of this now is that you have a number of grassroots organizations. The League of Women Voters is one of them. Rolling to the Polls is a local organization in Montgomery. That is another, and several others. When we talk about the Ordinary People Society, TOPS actually goes into jails to register folks to vote, because there are people incarcerated who still have a right to vote because they do not fall under these lists of a crime of moral turpitude, or as it relates, they're not outstanding fines and fees, right? So they still have the opportunity and the ability to vote inside. But our job is to do a couple of things. Yes, we still have to keep reintroducing, our voter restoration bills, but we also have to make sure that we are getting out in community and not just registering people to vote, but ensuring that we are meeting people where they are. Oftentimes there is this narrative, if I have a felony conviction, I can't vote. And that is just not true. What we have to do is understand what that means. So that means community organizations being able to meet people where they are, but that requires some tools. Folks need Alicorp. Folks just could not register folks to vote and not have the details in which are necessary for folks to be able to utilize that particular, use their voice in that way. And I think that that is a big thing. So we want to continue, one, ensuring that policymaking and advocacy is consistent. We want to make sure that automatic restoration is something that we are constantly advocating for. And two, these clinics are necessary. We need to be able to meet people where they are. The ACLU of Alabama, we do a series now called Atoning Alabama, in which we are trying to ensure that we are providing the tools that people need to advocate for themselves at the board, at the Pardons and Parole Board, to ensure that they can get paroled, and to ensure that they have the tools to understand what it takes to get a pardon. That is that is just a step in this ultimate process to be fully re-enfranchised. And so I think we need a multi-pronged approach. It has to be a policy and advocacy initiative each and every time. Even if that bill doesn't get to committee, we have to introduce it every year, and we have to press and work within our coalition. And also we have to meet people where they are, whether it is these clinics or ensuring people just have the tools to know how to advocate for themselves. At the Board of Pardons and Parole, this is just a step in ensuring people are empowered to ensure that they are advocating for themselves for full re-enfranchisement. And full re-enfranchisement means many things. It means not just rehabilitation, but reentry, being able to step up and to understand the power of the vote, and also telling people, hey, we understand that your voice matters and this is the reason why, but we also have to demonstrate and how we are showing up in community, and making sure that we are clearly communicating to people why that is important. And one of the reasons it's important is because that bill is passed and voted on by people you vote for. So we have to get to it at the very, very basic level. People vote for individuals who are willing to advocate for them. I would love to see somebody in the state legislature who is formerly incarcerated and understands the power of that policy and the power of full and re-enfranchisement. But maybe if we get enough people fully re-enfranchised, we're going to have the power of the vote to actually get a candidate that can do that. So that is part of the full scope of why these things are so important.
I love how you can say all of this with a smile and you always end the positive spin. But by and large, y'all, this conversation has just been a lot. So we're going to look at the end at some new threats that are just emerging, but let's just take a moment to cleanse and be positive. Just a moment. I want to go to our three panelists who are working in litigation and ask, starting with you, Imani, what legal strategies are working? Where are some bright spots?
Sure. So I have to clarify, I don't work in litigation. I'm on the policy side. But of
Okay.
course, LDF has been involved in Georgia, specifically around the SB 202 case that seems to never want to end. And, SB 202 is arguably the most bold and shameful voter suppression legislation in modern era. But there were some wins in terms of preliminary injunctions that happened. And so the litigation that we brought with ACLU of Georgia, SPLC, and some law firms challenges multiple provisions in SB 202, like the ban on mobile voting, and perhaps the most cruel ban on line warming, which is where volunteers provide water and snacks to Georgians, and those disproportionately people of color who are waiting needlessly in long lines. And so we asked in this course of litigation for 5 preliminary injunctions, and the federal court granted 2 of them. So they enjoined the requirement for the date of birth to be on absentee ballot envelopes, and also enjoined the requirement, a part of the line relief ban. So for the line relief part of it, it applied to the ban that about providing food and drink more than 150 feet beyond the entrance of a polling location. And so you can do that, and the court found that that ban would have been substantially likely to be an unconstitutional restriction on expressive conduct under the First Amendment. So in general, in Georgia, any legal strategies around addressing misinformation and disinformation, addressing voter ID issues, ensuring access to absentee ballots would be very helpful for voters of color overcoming suppression and casting their ballots. In Alabama, we've seen some settlements happen that kind of include requirements that address suppression and turnout. So this is a very old case at this point, but in 2018, we brought a case against an at-large system in Pleasant Grove, Alabama. And under this at-large system, there had never been a Black candidate elected to the city council. This led to a settlement agreement, and one of the provisions in the agreement was that the city had to implement ongoing voter education and training programs to educate voters about the change, about how at-large works versus cumulative voting, to make sure to bring in historically disenfranchised voters. So in terms of Alabama, legal strategies that would champion no excuse voting by mail, broad acceptable IDs for voting in person and by mail, and early voting would be very helpful for Alabamians of color to overcome suppression and get out to the polls.
Ajay, can we come to you? You got any bright spots you can share with us? Legal strategies that are winning?
Boy, legal strategies that are winning. I'm not sure I have a lot of good news to share on the legal strategies that are winning front. As far as voting rights go. I mean, I think, well, I will say, one thing that we worked on at SPLC in partnership with a number of other organizations. There is this issue of kind of mass voter challenges that we've seen crop up in Georgia. Georgia changed its laws recently, allowing private citizens to bring kind of indefinite number of challenges to voter registrations, in bulk. So we saw 6 individuals in Georgia, in I believe it was in 2022, file about 100,000 challenges to voter registrations all across the state, and they can do so on just kind of the most flimsy of grounds. A lot of what this ultimately does is it ends up creating like a huge, it's a big resource suck for counties that are tasked with investigating this. There was some effort to try to do by some of these private individuals to bring these types of challenges very close in time to an election, within 60 days of an election. I think the statute allows these individuals to bring challenges up to 45 days. There were efforts in litigation to sort of push back on that and try to push, ensure that those types of challenges didn't end up disrupting elections or getting people kicked off the rolls, in the lead up to an election. Well, most of which have been successful. Ultimately, we're not looking at, decisions on the books that say, these laws violate the NVRA, which is ultimately what I would love to see, and I think ultimately which we will see. I'm hopeful, but that said, it was nice to see a win on that front to sort of push those off.
Thank you. Danielle, do you have any wins to share?
Yeah, I mean, listen, Ajay's not wrong that like the overarching kind of you legal landscape is really hard, but I actually think that like the lesson from that is that the good news is that we have all these groups on the other side, on this side of the voters that are just dogged. And I think that that's like how you get the wins, right? You're going to get a lot of loses. You're going to rack up loses, but you're also going to end up with wins. So, for example, Alabama passed this like horrendous law, criminalizing, this is something Amani kind of talked about at the beginning of her remarks, criminalizing kind of like attempts to help people navigate the absentee ballot process. We represent folks along with the ACLU of Alabama, and gosh, is it SPLC? Are you guys on that case? My brain, great partners in that case. And we brought up, LDF is definitely a partner in that case. And, listen, we had a broad First Amendment theory that I think is righteous and I think should win long term. We didn't win on that, but we did win on a narrower claim about kind of helping voters with disabilities and a part of the Voting Rights Act that protects voters with disabilities. And that was a really important, incremental win. Again, in Alabama, we sued over that crazy kind of attempt to find non-citizens on the rolls at the last minute. And, by the end of that, preliminary injunction hearing, Alabama had really embarrassed itself. It had to recognize that over 2,000 of the 3,000 voters that they'd identified, they had already confirmed were in error in being on that list. And that attempt was not only enjoined, but they kind of threw out that whole process and recognized that it was a failed effort. So there are wins to be had. In Georgia with the SB 202, we had a case that was kind of focused on some of these restrictions on absentee ballot assistance. And, they had a rule that was just frankly stupid, that you had to have a disclaimer on the absentee ballot application that said this is not an official government publication, but it was required that you use the official ballot application if you were going to help folks. And, we were able to point that out in litigation. They actually changed the law to edit the disclaimer to something more reasonable. And so I think the only way to rack up the wins here, and we're doing it as a coalition, the groups here and so many others, is to just be really dogged in holding the line, and to not be discouraged by the fact that, you have to lose in order to win sometimes.
And I think it's important to point out that the headlines of the bad stuff always hit the news, and it hits hard. When you guys quietly win the lawsuits or get injunctions, it's very quietly reported. It's not celebrated as loudly and screamed from the rooftops like all of the awful legislation and policies that come through. So there is good stuff happening out there. One big win, Jatan, that I want you to speak to, but kind of gets a little confusing, and is it a win, is it not, was Milligan versus Allen. I mean, that was huge, had a positive impact on redistricting in Alabama. But we also have political redistricting news coming out of Texas and California that are basically gerrymanders that have also been in the news a lot. What does all of this news about redistricting mean for an average voter?
So, Stephanie, I really appreciate you elevating this, because there are a couple of points that I want to make. Essentially, what Milligan did was establish that there was a need for a second majority minority district, a second Black district. And we made this decision after the census. And so there was an assumption that there was going to be a reduction in Alabama's population during the 2020 census. What we saw is there was actually an increase in population by nearly 500,000 people. And the majority of those people were folks of color. And we saw that they were no longer in the rural areas. They had actually, we saw an influx of folks in more metropolitan city and suburban spaces. And so when we talk about redistricting and the reapportionment process, I really enjoy talking about these things because gerrymandering is a big legal word, right? So, our Voting Rights Project and folks talk about, well, gerrymandering, what is it? And it's really just about the redistribution of resources. So we have to determine how many people are in a community to determine a few things. How are they represented? What are the resources that they get? And that includes water and waste and who's on your school board and what resources go to your community center. So the very, very basic things are part of the redistricting process. And what's also important in this redistricting process is ultimately people need to be able to vote for folks who have their interests in mind, who are going to Congress or going to the state house to advocate for their community interests. That's really what gerrymandering is all about, and ensuring that we are addressing it to well represent communities. And that is what the redrawing of the district lines mean. And ultimately, that is what the Milligan decision said. We were cracking districts and packing districts. So cracking districts, so ensuring that Black voters did not have that the power and diluting their vote. And then this is a big issue when we really push Black political power and power of community. You have to ensure that it represents what is needed. And you can only do that by data and numbers. And that's just the reality of it. So that's essentially what Milligan helped do. It helped redraw a section of the state to represent the actual population. And so we got a second congressional district because we had more people. And so Alabama only had one district, but you had more than a quarter of individuals in the state that were Black or communities of color. And so we needed more than one congressional district. So they created a second Black congressional district, and that is District 2. And what is important about District 2 is actually just about 49% Black. It is really representative of the people, right, in that district. And I think that's what's important about the Milligan decision is we have to ensure that we get individuals and we are redrawing the districts that represent the community. That is the power of gerrymandering and redistricting specifically, right? This is why I think Milligan's important because we lose that. So now we're like, okay, Section 2, are we still going to have it in play? And that's a bit more on Calais, and I kind of want to get to that. But ultimately, what Milligan did was it allowed that access. So Milligan gave Alabama a second congressional district, second Black congressional district, we'd say. It also, and we're talking about another litigation win, it also created, we were talking a lot about stuff that happened in New York a few weeks ago and in different places and many wins. But people missed an incredible win that really happened because of Milligan, and that was in Mississippi. Mississippi got 3 additional state legislative districts. And the reason that happened was Milligan helped pave the way for the state to say, these are districts that have to be represented and redrawn. And so that was a huge win when we saw those 3 legislative districts in Mississippi that Milligan paved the way for. And quite honestly, the issue that we're having in Calais, Milligan paved the way for because there was Robinson and there was Milligan. Milligan went to the Supreme Court. So ultimately, Louisiana has a second Black congressional district that they already have. And non-Black voters filed a claim and said, hey, we feel that our voice is not being heard. And that's why we have Calais. So Milligan has helped really allow us to talk about what state and congressional legislative districts can do when we are well represented. We also just had a win this week in Alabama where we have another state legislative district that has to be redrawn for our state legislature. So we got a win We filed in Huntsville and we filed in Montgomery. We won in Montgomery. LDF filed in Birmingham and won in Birmingham. So we are having these local wins that people often, to your point, Stephanie, it gets mired in all of the noise and all of the things that seem to keep us down. And the reason I have a smile on my face is because I'm a big believer that politics is local. And politics is local is because that is where the voice of the people are. And the issue that we have in this country is that we are constantly coming up against racist policies, discriminatory policies, policies to disenfranchise historically marginalized people. We are constantly coming up against the system. But what people are realizing is once the people have the voice and understand the power, that is when they move the political needle. And the excitement that I have oftentimes in these dark times is what people realize, is that they have the power to move the political needle. And while we may not see it every day in the headlines, those of us on the ground see those wins. And we know that the people have the ability to move and to change things. So yes, we have Mississippi and the 3 new state legislative districts, but we also have to think about what is that the state Supreme Court election going to look like? And what is that going to look like? That is going to likely transform their state Supreme Court. So we have to look at these wins as, yes, they are incremental, but they are incremental in times that are necessary and which our politics must be locally focused.
And we're going to be a little bit over time. There's 3 more issues I want to make sure we cover. And one, obviously, is Louisiana v. Calais. Ajay, can you speak a little bit about what that case is about? Because it's in the news a lot, but I'm not sure everybody quite understands it.
Sure. So kind of just building off of what Chetan just kind of described, in Louisiana, following the 2020 census, Louisiana went to go redraw its maps. I believe, I have to look back at the stats on this, but I believe it's about 30% of Louisiana's population is Black. Originally, Louisiana had 6 seats in Congress. They drew 1 majority Black district, and they were promptly sued by LDF and ACLU and a number of other entities. And with the argument that they needed to draw a second majority Black district under Section 2 of the Voting Rights Act, which, has a complicated sort of formula for, arguing ultimately that, if you have a compact Black population in a particular part of the state, and there's racially polarized voting, ultimately, there needs to be some effort to try to draw a district where that particular population can elect candidates of their choice, their preference. Plaintiffs in that case ultimately succeeded and won. Louisiana was then told to go back and draw a second majority Black district. When they did, some would say they intentionally drew a district that basically stretches from like Baton Rouge all the way to Shreveport. So basically like a long sliver across the entire state. It seemed like an intentional way of kind of inviting a lawsuit to kind of bring this issue to the Supreme Court so that the Supreme Court could consider the full extent to which, legislatures and other entities can consider race in redistricting, and specifically in the context of trying to comply with the Voting Rights Act. It's important. This is a hugely important issue because, as we've kind of alluded to in our, as my co-panelists have alluded to, the Voting Rights Act has, been responsible for increasing Black power all across the country, minority power all across the country, not just for Black communities, but also Hispanic communities all across the country, Asian communities in California and New York. It has been a significant tool in ensuring that there is representation for those communities in the state level, in Congress, at the state level, and municipalities. So ultimately, not sure what the Supreme Court is going to do. There's a lot of commentary out there that oral argument that suggested that they were very skeptical about, the Section 2 kind of operating the way it has currently operated. To the extent that there is a narrowing, I think, ultimately what you would potentially see in the near term, there are a couple of states that I think are gearing up already to potentially redraw their maps. Louisiana has shifted its election schedule to anticipate a decision from the Supreme Court and then ultimately redistrict in a way that would, without the Voting Rights Act as a potential restriction on how they go about redistricting. I understand that Alabama might be considering a similar effort going forward. I think the impacts will continue on. Once the 2030 census comes in and states, municipalities go back to drawing maps, you will start to see the full impact of not having this protection in place at every level of government.
And will you talk a little bit about the risks of the 2030 census and how important the accurate count is? Because we're still fighting the 2020 census battles. That's how all this redistricting is happening. But we're looking forward to 2030, and there seems to be some pretty significant risks that we may not get an accurate count based on policies.
Sure. So I think census manipulation is clearly a priority for the current administration, at least as prior practice serves as any kind of example. In the first Trump administration, there was an attempt to add a citizenship question to the census, which everyone knows, was widely recognized as potentially resulting in severe undercounts of Hispanic individuals as well as non-citizens. The Census Bureau also recognized it. It was ultimately overturned. That effort was ultimately shut down by the Supreme Court, not because of any reason relating to not being able to ask a citizenship question, but because the process was so arbitrary that the court ultimately said it violated the Administrative Procedure Act. What that means effectively is that you have a second Trump administration in office now, and they have a second bite at the apple, and they basically can use the time they have in office to take the steps they need to take to try to add that question or a question about immigration status onto the census form, which I think would have detrimental impacts ultimately to response rates and potentially to the accuracy of the count. Separate from that, there was also an effort to try to remove undocumented persons from the census in 2020. We know that there are a number of states that are very much interested in pursuing that policy once again. In fact, the state of Louisiana, in coalition with a couple of other states, has actually sued the Census Bureau and the Commerce Department, asking to have a declaration from a federal district court saying that undocumented persons shouldn't be included in the census, even though the Constitution says that the census should include the whole number of persons in each state. So that effort is ongoing. We expect that there are sympathetic voices in the Trump administration on that front, given that they attempted to do that in 2020. The part of the reason why they failed in 2020, not just because there was a change of administration, but because the Census Bureau really had no way of knowing what the number of undocumented persons in the country was. They didn't have an accurate data set ultimately to be able to do that. It seems to be something that they're working on currently based on all of the headlines about, information sharing across agencies and data collection from the DHS. So I would anticipate that is something that is in the works as well. These are all risks ultimately to, potentially, I know it's 5 years off, but ultimately these are things, census preparation takes about 7 to 10 years before the census. And, I think having failed the first time around, I think the administration learned its lessons and is trying to go about building the record it needs to implement these policy changes for the upcoming census. And it could have extremely detrimental impacts on the accuracy of the census.
It is hard to predict the future, but it is important to be prepared and looking ahead. So this is going to be the final question. And Jadhan, I'm going to send it to you, and then I'm going to give everybody a chance to wrap up. Looking ahead to the 2026 election, people are growing concerned that there is the potential for law enforcement or even National Guard to be intimidating voters at the polls. Is this a real risk? Is this something we really need to be thinking about? And how can communities start to prepare without creating fear?
The answer is the question is, should we be fearful? Absolutely. We're seen on television every day. The militarization of the state against our communities in areas and in spaces that people would otherwise never think that intimidation or the disappearing of people would be happening. And so intimidation at polls is absolutely something that is actively happening. We have the ability, quite honestly, to use our voice. We have to advocate. We have to tell our Congress people this is an issue. We have to talk to folks at the municipal level and say this is an issue and this is what we are concerned about and this is why we are concerned. And so I always think the most effective way to address issues that impact us day to day is talk to the people that we have voted to actually uphold these things. There is very little, I think. We are limited in what we can do at the federal level. We have a lot more power around what we can do locally if we use our voice. And so when we have groups like those on the call, the Southern Poverty Law Center and Campaign Legal Center and LDF, what I have found or what we have collectively found that has been strong in coalition is oftentimes sending these letters to our Secretary of State, which we know are not friendly to our issues. But collectively, when we send those letters with so many signatures, when we send these letters to ALEA, the Alabama law enforcement agency, and let them know this is a concern, we put it on record. It is for posterity. It is to say, these are our concerns. And we are laying them out very, very plainly. And that is a real way that we can address what is going to happen, anticipate, and also election protection work. The ACLU of Alabama has housed our election protection coalition, in which SPLC and the League of Women Voters have been very active participants. And that's one of our best tools are our advocacy letters to our elected officials and to folks that we understand must, to Kathy's point in the chat, must be the standard bearers of election integrity. It absolutely does go both ways. And that is the narrative that we need to be owning, is election integrity and protection for our upcoming elections and for every election. And so that is a critical aspect of what we do. We remain in coalition, we use our voices consistently, and we hold to bear the individuals and our local law enforcement agencies to the standard of our expectation. And also understand the National Guard is, while it's the current administration has decided to federalize it, the National Guard is still run by the state. It is still run and dictated by the governor. We have an obligation to consistently name that. And we oftentimes have to use our best messengers, which may not be those of us sitting within these organizations. It may be the veterans. It may be those individuals who understand law enforcement intimately and understand what it requires to ensure that people remain safe. And so that is an important aspect of this work, especially now, and especially as we're looking towards the 2026 midterms, and quite honestly, elections that are happening every quarter in some capacity for the next 24 months. And so that is just, I think, such a critical aspect is our collective voice and utilizing that and holding to account our elected officials who are there to protect the people.
I know we didn't cover everything that everybody on this panel wanted to cover or everybody in the audience. But I don't want to keep everybody late. These folks have given us their time, and we do have some folks that are in Eastern time zone, so they're even an hour ahead. Let me go ahead and give everybody a minute or two to wrap up. Any final comments you want to share? Imani, we'll start with you.
Okay, well, thank you again for including ODF in this panel, and I love being on the panel when I learned something as well. I just want to leave with two thoughts. One, I encourage everyone to look up what a state voting rights act is. In Georgia, there's potential for one. In Alabama, there has been one introduced. And these are an example of state policy that is affirmative, that is not just about fighting bad laws. And I think everyone on this call who have been working on those at the state level and on the national scene, that's what I do exclusively. But as we are thinking about whatever the frontier is for voting rights in the Deep South, I think there's three things to keep in mind. One, more than ever, Black voters cannot afford to leave any power on the table. Every election matters, and every ounce of wins matters as well. Two, fair representation matters, and that's why the redistricting fight is, in the news, and it's something that is on everyone's mind. And then three, an intersectional framework is necessary to advance equity and Black political power. Elections directly impact resource allocation, directly impact where you go to school, etc. And so remembering these things, I think, can make our wins more impactful and also help us reach voters who might feel disenfranchised just by the system and not feel like they're being counted. So yeah, those are the things that I would kind of leave this audience with.
Thank you, Imani. Danielle, do you have any final thoughts you want to share?
I'm going to close with one kind of final thought, which is when I started doing this work in 2015, we were living in the wake of Shelby County. We were seeing really stark cutbacks on voting access, especially in the South, and not a lot of people were paying attention. And there are a lot of headwinds these days. I mean, for goodness sakes, the last question was about the National Guard and intimidation at the polls. That is a scary moment to be in. But the energy of Americans to focus on protecting their democracy has never been stronger. I have never kind of encountered more people in my everyday life who are kind of keyed into these issues and passionate about them. And I think that's, more than in the courts or even in state houses, we are going to win this fight for democracy because of the energy of folks, everyday folks who are finally keyed in to the dangers that our democracy is facing. So that's where I get my hope from. Stephanie, you asked about talking about hope. And that's where I get my hope from. And from, that folks are spending their Tuesday evening with us, talking about the wonky ins and outs of voting rights. So thank you all for your time tonight.
Thank you. Ajay, you're next.
Yeah, so I don't want to be the dour person on the panel.
Somebody's got to do it
all day. It has been, obviously, I think as everyone has kind of indicated, it is a really challenging time to do this type of work. But, I will end on a hopeful note. I take heart from the fact that, we see ballot initiatives all across the country, pro-voter access ballot initiatives in Florida and Michigan and Alaska, and they win every single time. And to me, that is an indication that the broader American public sees these issues as these are popular. This pro-democracy is popular, and the efforts to restrict, that's the minority view. And ultimately, I just don't, I believe as we're going to keep pushing, we're going to keep mobilizing, we're going to keep fighting, and the will is there on the public, and we're going to, ultimately be able to push back effectively against this, this extreme minority trying to take this right away from us.
Jatan, final words.
I think this question is important. I always like to use this quote by Reverend William Barber, which is, "The South is not red, it's suppressed and it's under-resourced." And I think that is what helps, to me, not just dictate, but it's almost the North Star as to what our next steps are. I had the pleasure of the honor of speaking at a No King's Day a few weeks back in Birmingham, and wrote an article that says, so you attended a No King's Day, now what? And one of the things that I thought was important is because we really don't always have next steps as to what this next frontier looks like. And I love threes. I am the granddaughter of a Baptist preacher. And so there's always like threes and an alliteration in some ways, or a rhyme. So educate, activate, and collaborate were the things that I focused on. We have to educate ourselves in local politics and what is going on. And I love the fact that Ajay used the ballot measures that we're seeing nationally that are actually winning and gaining traction. And so we have to educate ourselves about what's going on, because it's so easy to get mired in the things that are not going right. And activating. So once we educate ourselves, we have to activate. And that's really investing our time and our resources. And sometimes our resources, quite honestly, I'm really about resources and funding. That's what is going to be a key aspect of this. But resources also looks like our time, but it also looks like our attention. We cannot be so mired and distracted by things. I know social media and Facebook is a area in which it allows us to really, doom scroll and get distressed, but it also minimizes the things that we can do when we really activate locally. And the next piece is collaborate. And I think that is what so many of us are already doing on this call. This is a collaboration with the League of Women Voters across 2 states talking about our issues. And so we're doing so much of that right now, educating, activating, and collaborating. And that's important. And the last thing I'd like to leave us with is a quote by Mariame Kaba, because everybody has mentioned it. She often says, hope is a discipline. And that is what she uses. And we have reframed this in some way to say hope is a strategy. And so as much as we get distressed, we often have to understand that this work is not going to happen in another election cycle. So we're talking about 2026. I'm thinking about 2036. We have to understand that this is decades long work. And we have to be invested in that decades long work to really see the power of all of the investment and all of the folks who are doing this, like Ajay, like Danielle, like Imani and Stephanie, and so many others. So that is what I would like to leave us with, is understanding that that frontier requires us to be deeply invested.
I was at a community Thanksgiving service last night, and the pastor here in Birmingham, the Pilgrim United Church of Christ, gave the message, and he spoke beautifully about how gratitude is our power. I am so grateful to be in coalition, in partnership, in collaboration with all of your organizations, with our partners in the National League of Women Voters, League of Women Voters of Georgia and Alabama. When we carry this burden, we can do it together. We don't all have to carry it all the time. We can pass it, we can share it. And I'm so grateful for sharing in that burden with you. Thank you for your time. Thank you all for being here and for sharing your expertise. Thank you to the audience for being here with us. We appreciate your time on a weeknight. I'm going to pass it back to Kim Bailey, president of LWV Alabama, and Nicola Hines, president of LWV Georgia, to share final thoughts and action items. Kim, over to you.
Thank you so much, Stephanie, and the panelists. I just can't tell you how much it means for all of us to come together and talk about these things, these very important things. This conversation sets the stage for Alabama's upcoming legislative session, which starts on January the 13th. And there are already several pre-filed bills that we are watching closely, that we will be educating and advocating about. And so we encourage you to, be on the lookout for those as well, for calls to action that come out, and contact your legislators, because your voice matters. It can make a difference, and they work for you. And you need to be sure that you let them know what's important to you. And these voting rights bills that are coming up are critically important. So let's get ready and do the work. And I'm going to pass it back to Nicola to close us out. You're on mute.
Thank you. Thank you. Sorry. It's been a long evening for us. East Coast as before. Do want to for this evening for Good Trouble Tuesday, the fight for the ballot box. On behalf of the League of Women Voters of Georgia, I want to extend my deepest gratitude to our panelists, Women Voters of Alabama, for partnering with us, and to each of you time to be part of this essential conversation. As we reflect what we've heard tonight, let's remember that protecting voting rights in the Deep South requires more than awareness. It demands action. Georgia and Alabama remains at the heart of this fight, and what we do here truly ripples across the nation. In Georgia, our work continues. The 2025 Assembly session resumes in January, and we're already preparing to monitor legislation, advocate for transparency, fairness, and access at every level. And while many November elections here in our state have wrapped, we are not done voting. As most people know, in Georgia, we vote almost every year, almost sometimes it feels like every other month. In fact, because we have runoff elections, and we have a couple that are taking place across Georgia. On December 2nd is our general municipal runoff date. But we've also had special elections, and those special elections runoffs will be held on December 16th of next month. If you or someone you know live in the runoff areas, please check your status and make a plan to vote in the elections. As we all know, local votes and local races matter the most. And before I say good night, allow me one slightly selfish plug, if you don't mind. LWGA, if you're in the state of Georgia, is hosting our first ever holiday toast to democracy on Saturday, December 13th at 3 p.m. And it's just to celebrate all the hard work we have been doing for the last couple of years to help fight democracy, especially this past year. It'll be an afternoon of connection, celebration, and recommitment to the fight. So keep an eye out for more details in our newsletter and our social media platforms. Lastly, mark your calendars, because if you notice, our pattern is once a quarter, we are doing a Good Trouble Tuesday event, and we will definitely be returning in our first quarter of 2026. We'll announce the date soon, so be sure to follow us on Facebook, Instagram, subscribe to our email list so you don't miss out with our next event. With that, I want to thank you again. Continue to raise your voices, hold the line, and push the fight forward for all of us, not just in the Deep South, but across the country. Thank you again, everyone, and have a good night. And remember, keep making good trouble.